for the invitation. It's good to be here. I know I'm the graveyard lecturer. I will be fast and brief and hopefully useful as well. My background is, Mark Mimler, I'm a senior lecturer now. A week ago I got promoted, which I was very happy about, when I first did the slides, at Bournemouth University, which is in the United Kingdom, but obviously you can hear from my accent, I have German blood in me. So I did my undergrads in Germany and then did my masters in the UK, did my PhD in the UK, and decided to stay, even with Brexit. I mean, the good thing is I have German and British passports, so it doesn't really bother me that much, although it bothers me very much. But that, of course, is a different thing to talk about. So my graveyard talk is basically about giving you a snapshot about the IP landscape. I am probably aware that many of you are aware of IP, but I don't really know the level, so I will try to go through the different areas of IP which could be relevant for the MedTech sector. As such, I think I can actually spare section one. I just put it up because it was very, very interesting for me to look at the industry as such, because I've been doing some research myself recently on medical technology, specifically with regards to patenting, so also like how software is applied to MedTech and so forth. And also with regards to bioprinting. So that was something which I looked as well with regards to our research. Now, I think, yes, we can keep this rather short. What I found interesting is, of course, like as a relatively high industry with a lot of intellectual property around, it is quite big, very big, and that's sort of like what I found in my research. But in comparison, for instance, to the United States, there was, it says in this report that I found, that 95% are small and medium enterprises. Now we heard that small and medium enterprises mean something else in the United States than it does in Europe. I could understand. I think for us it's 250 minus, that's sort of like the definition of a small and medium enterprises, where you wouldn't have, sort of like, many times you don't have in-house IP departments, so normally you would have to get your expertise inside from, for instance, patent attorneys. Quite interestingly, one of my former students is a patent attorney in medical technology. And I looked at his website, I actually gave him a ring as well to say, like, okay, so what are you guys doing? What is actually relevant for your clients when you look at protecting their innovations and going abroad? So I will give you sort of like a snapshot of what he said with regards to protecting your intellectual property. So brief introduction to intellectual property. Of course, it protects intangible goods, creations, innovations, of course. I will go very shortly by this, but sometimes when you look, there's sort of like a joke amongst IP lawyers, when do newspapers get it wrong? When they talk about something as copyright and trademark, and they get it completely wrong. They call something as trademark, which can't be trademark because it's copyright protected and so forth. So sometimes it's good to sort of like be aware of like the different categories of intellectual property given by this definition of the intellectual property organization as such. Sort of like we have like these big fields of intellectual property, copyright or author's rights. I mean, did you ever think about why we call it copyright in the United Kingdom, but it's called droit d'auteur, diritto d'autore, derecho d'autore, Urheberrecht? They're sort of like they come from a different standing, a different philosophical understanding, which in practice actually has different applications. Thinking, for instance, about moral rights, sort of like your attachment as an author to a work that you have created. It's also quite relevant when you think about like employees' works. So what in Germany, in the United Kingdom, if you do a work in the course of employment, it belongs to the employer, by definition of the law. On the continent, many times you have to do this contractually. So this is also something to be aware of with regards to copyright. Now, copyright, of course, is not going to be the main part of my presentation today. Industrial designs is potentially relevant, of course, for the MedTech industry when you think about ornamental aspects of your devices, because they could be protected by designs. And of course, in Europe, we have a so-called community design, which gives you protection for 25 years. Via the office in Alicante, where you can get that. So that might be something also interesting for these issues. Sui generis rights, you don't really have to look at this. Unfair competition potential. Unfair competition, la concurrence déloyale, it's called in this country, which is sort of like an art of civil law tort, but it's not really very much harmonized throughout the European Union. As you may know, we have a lot of harmonized European rights. Which rights are harmonized? Do you know? Which IP rights are harmonized? Sorry? Patents? By the European Union? There is no EU patent as such. Exactly. I mean, that is done by the European Patent Office, which you obviously may know. But the European Patent Office, and this is what I always tell my students, if they get it wrong, they fail the exam. At least I threaten them. If they mix up that the European Patent Office is an EU institution, it is not. So of course, that when we think about rights that have been harmonized throughout the European Union, we first and foremost think about trademarks and designs, where you have a unitary right which is valid in 28 member states. But then of course we still have national rights as well, which of course then is relevant for your strategy of how you want to go ahead to protect your intellectual property. In future, we might have something resembling to an EU patent, which is the patent with unitary effect. Apparently everybody's really excited about it. Let's see whether actually it's going to happen. As you know, Brexit was not very helpful for it. But there's also the Germans currently. They have an issue in Germany because there's a constitutional complaint before the Constitutional Court for this issue. So, of course, patents are the most important right here, of course, for medical technology, because patents protect technology. Patents protect technology as such. So it is sort of like the prime right that I'm going to focus on my presentation on as well. When we look at like the layers of laws that we have with regards to intellectual property, we will see that there are different layers. There's, of course, like the national layer, where it all started from, where sort of like IP laws endemically were created. But then, of course, with growing trade, starting in the 19th century, there was a need to create international norms on intellectual property rights. So, for instance, you have the Paris Convention of 1873, which is actually quite old. But think about like the ages of industrialization, where the need was seen that we have to harmonize our intellectual property rights with regards to patents as well. And most importantly, like quite recently, we have a worldwide spanning IP agreement, which is the TRIPS agreement. The TRIPS agreement, which awkwardly is governed by the World Trade Organization. And of course, the TRIPS agreement talks about trade-related aspects of intellectual property rights. The cool thing about TRIPS is it harmonizes. It sort of like gives minimum thresholds for IP protection throughout the member states of the World Trade Organization, which sort of like gives us a feeling like what is actually protected in the member states of the WTO. And the TRIPS agreement also added additional rights, like for instance for broadcasts and so forth, were also like pushed into the international canon and have to be now protected in all WTO member states. So it's good to look at these international initiatives to understand the complexity of IP laws and sort of like what can be protected and how it can be protected in which jurisdiction. And of course we have our regional influences here by the European Union. We have the EU trademark and the community designs. Patents maybe too. And copyright was quite substantially harmonized by the European Union in form of directives as well. With regards to a patent law, we have substantial harmonization of European patent law, of national European patent rights through the European Patent Convention. It is of course like the convention that is operated within the European Patent Office, but the member states of the European Patent Convention decided to harmonize their laws according to the European Patent Convention, obviously not to have any inconsistencies between an European patent and a national patent as well. So we have like a quite substantially harmonized law, but of course, like, that's why we're lawyers, there's of course like different ways of interpreting the law. That's why you need to hire lawyers sometimes to give clarity into understanding what the law is all about as such. So it's important to see that we have these different layers of law as well with regards to intellectual property. Of course, patents first and foremost is sort of like the relevant right here because it protects technological innovations. as such, but also copyright I've mentioned. And copyright, if an aspect of one of your products can be protected by copyright, it is very attractive. It is very attractive because you do not need to register. It is automatically registered. It's automatically protected in worldwide, basically based on the Berne Convention from 1876. So copyright is sort of like the first go-to rights. And I've been doing some research into 3D printing, and I've just been to a workshop in Brussels 2 weeks ago when we looked at like how can this technology, for instance, like the CAD files that sort of like instruct the printer, how do we define them? And the American delegate who was there, she was a representative from the USPTO, she said, "Our copyright is really attractive for this technology because we do not need to register. We do not need to think about like, which jurisdiction we need to register our patent or design because we have automatic protection." So it is kind of like quite interesting. But of course, like the applications for copyright for medical technology is of course quite limited. Trade secrets, of course, is also something which is very relevant, so confidentiality and so forth, which is basically a Coca-Cola recipe is always sort of like the main example, that you keep something secret, and if it then is disclosed unlawfully, you have certain measures against the person who discloses it. Now, the law in the European Union was quite divergent. For instance, the Swede, they had statutory law on trade secrets, whilst in Germany and in the UK we sort of like had tort or other measures on how we protect that. There was no dedicated law for that, but the European Union decided to devise the Trade Secrets Directive, which is now in process of being implemented in member states. The UK, for instance, the UK is actually following it. They are going to implement it, but they already said we already complied. So we are basically already compliant with the Trade Secrets Directive. Some jurisdictions may have to adapt their law in order to give justice to the Trade Secret Directive, but that has to be then implemented in the future. Trademarks, of course, are quite interesting. That is something that my student has told me. When they sort of look about medical technology, of course, patents is the first go-to right, but they also look at a specific trademark policy and how and where to protect the name of the device, for instance. So that is also something which can become important as well for trademarks. And trademarks can actually give quite broad protection for the product that you have and the brand name that you have. Designs I've mentioned as well, that could be used for ornamental aspects of your product. They sort of protect the stylistic features and the appearances of your product, so that is something to go to as well. And there's of course like national design rights that we have that have been harmonized through EU law, but also like the community design, which of course gives you protection throughout the 25 member states in the European Union. The Americans have also design protection, but they call it design patent. They call it design patent. So there is of course like utility patents, which is sort of like what we call patents here in Europe, but a design is there called a utility patent, which gives similar protection to what we have here in Europe as well. Unfair competition I've mentioned as well, this also can protect the get-up of products. So this is I don't know whether you've seen this in the United Kingdom, the Jif lemon. Somebody tried to make a reproduction of that, and that was actually stopped based on unfair competition law in the United Kingdom by passing off. This is of course a famous decision because this is the iPad, as you remember. This is sort of like the crappy Galaxy Pad apparently. I don't know whether it's crappy or not. But of course if you look at them, they're quite similar. They look quite similar. Now what happened is, this is basically based on a German decision, and basically what was said in that decision is that the Galaxy Pad reaps the reputation of the iPad because it looks so slick and so forth. And basically the German courts have argued is because the Apple iPad has so much reputation, it would sort of like misappropriate the reputation of the iPad. And that's why Galaxy had to change it to this one, based on this decision, based just on unfair competition law in Germany. And the UK is actually, they have lesser protection for the scatter under unfair competition law, and they actually want to copy German law, which is kind of awkward now thinking about the political sphere now at the moment. Now, patenting of MedTech is of course the important issue that I want to talk about. And if you look at the data of the European Patent Office, it's actually the field which has the most patent applications in the European Patent Office in the healthcare-related technologies. So it sort of like had a dent up in 2016, but I think there were over like 12,000 applications given. So it is of course like a big field for patenting. And when we look at like which companies are basically applying for MedTech patents, we'll see like that the top 10 applicants, 3 of them are based in Europe, so the big players. But however, most of these top 10 applicants for European patents are from the United States. So the question is like, okay, is there sort of like a lack in strategic thinking of how to patent MedTech in Europe or not? So that was something mooted in the literature. Now, when you think about patenting your devices, there are certain criteria that one has to consider, of course, before going to the patent office. As such, medical technology is patentable because patents are available for any invention in any field of technology as such. So the ex ante patents are available for a lot of technology. However, as you know, a patent has to be new. It has to be, your invention has to be new in order to get a patent, because you couldn't patent the wheel again, because you could monopolize something that people have been using. So these criteria, the so-called patentability criteria, are of course quite important to consider when thinking about patenting. I also I hinted like two issues with regard to excluded subject matter, where you have methods for surgery, therapy, and diagnostic methods. They are also excluded, but then again, when you have a product, a medical product, that does not fall within the exclusion. And computer programs are, as such, also excluded from patentability in Europe. Now, these are sort of like the patentability criteria that I've mentioned to you. The most critical one, the most complicated one, is the second one, the inventive step. The inventive step sort of like suggests that your invention has to be non-obvious to the person skilled in the art. So it can't be a trivial workbench extension. It has to have some sort of quality that separates it from the state of the art. And that, of course, in practice, we find it quite difficult to address this provision, to see whether there's inventive step or not. Novelty is quite easy to establish, but the second criteria is the most complicated one, of course. I just highlighted here like the exclusion for methods of medical or veterinary treatment, because earlier we looked about the mechanism to the apparatus to remove the ticks. That of course would be patentable because it would not fall within the exclusion, because only methods are excluded. Only methods for medical or veterinary treatment are excluded. Products are not excluded. And this is sort of like, if you look here at the Article 53 of the European Patent Convention, it says that the exclusion does not apply to products in particular substances and compositions. As we know, the pharmaceutical industry is sort of like the biggest customer of the patent system. So obviously you wouldn't want to shoot into your own foot. So the methods as such are excluded from patentability, because it was said like, well, methods for medical treatment is sort of like what a doctor would do, and we do not want to give exclusive rights over that. But of course, like with regards to medical technology, we're normally talking about products that would not fall within this exclusion as such. And always bear in mind, as lawyers, we talk about rules and exceptions. The rule is, you shall get a patent. Exclusion means that, okay, that is sort of like an exception. We tend to interpret exceptions narrowly. We tend to apply them narrowly. So in order to give the rule a go, the rule should be ruling as such, and the exception should only be given in exceptional circumstances as well. So we tend to apply these exceptions and try to interpret them quite narrowly as well. And here's sort of like just some data that I found from the examination guidelines of the European Patent Office with regards to the exclusion of methods for medical treatment. So, for instance, the treatment has to be on the human body in order to be excluded. But if you sort of like take the whatever blood or whatever treat blood, it's not anymore on the human body because we are applying this exception very strictly. So if you say the treatment has to be on the human body, it cannot be, the exclusion does not apply if the treatment is done outside of the human body. So this is why they can be quite stringent here as well. Also, treatment of a dead human body, for instance, this does not fall within the subject matter. But for our purposes, we should like basically look at the rule here that the provision does not apply for products here. But this is just to make this presentation complete. Secondly, of course, like many times, software is applied in medical technology as well, and software as such is excluded from patenting. Software as such is excluded. That is prescribed by the European patent law, and this is one of the most complicated provisions that we have in patent law. And normally I take about 45 minutes to explain this to my students, which I have to do in February again, to explain how then computer implemented inventions can then be patented. Because of course there are computer implemented inventions. The only thing is like, how do we define as such? Because only computer programs as such are excluded from patenting. So normally it's sort of like what we do, and this is now very, very short running through what I would do in 45 minutes. The European patent law has been quite lenient. It has applied this any hardware approach, which basically means in a very, very simplified and dumbed down version is you put software in a machine, it does something, apart from just operating, then you can get a patent. Very simplified, very, very simplified. And this is sort of like the European patent law has been criticized for this approach where it says it's far too lenient on allowing computer implemented inventions. And it was of course blamed because the European Patent Office makes money out of granting patents. So there was sort of like a certain bias here by commentators with regard to computer implemented inventions. But anything sort of like if you put the software if you put the software in hardware, it does something beyond its own natural features, then you can get a patent on it. Now, with regards to medical technology, I've done some desk research to sort of like what are the most important things to consider when you go into patenting. It says like consult a patent attorney. So the first thing that you can find, and this is of course like what my student has told me, like yes, we are of course experts in this, so come and ask and talk to us. And the idea is like of course you want to go to patent attorneys, and this might be something interesting to hear from you as well, like to what extent are patent attorneys like trained to think strategically as you have to be, because many of our presentations were very about like entrepreneurialism and sort of how to think strategically. And then of course like good patent attorneys have to think strategically as well. So what you then sort of do is consult a patent attorney, establish a patent portfolio, but then of course it's based on money and your aims with the technology that you want to have. Because and of course, like what you should try to do is get the broadest protection as possible. But then, of course, your patent attorney will give you an advice to what extent you could get a patent on the specific invention that you have. What I've mentioned as well is looking at designs as well. Maybe there is something which is ornamental about your device, which could then be protected by designs as well. I mean, you will see that many times, of course, patent attorneys make money out of it, but they will try to pile as many layers of protection on one another as well. Also think about like the term of protection, because you know patents are protected for 20 years, designs are protected for 25 years. If you now look at copyright protects 70 years after the death of the author. So also like the term of protection is also relevant when we look at what IP rights are relevant for our purposes here as well. What I also find quite interesting as well is looking at patent landscaping. Sort of like when you're trying to get into the market, ask a patent attorney, this is what they do, and it's sort of like scanning what competitors are doing, and they can wonderfully visualize, it looks almost beautiful now, this kind of like patent landscape, that you can have here. And in order then, in this patent landscape, try to find your white space where your innovation could actually like then fit in, and to see like what basically competitors then are doing as such. So it's important to see what competitors are doing, and with this patent landscape you can try to find the white space basically within the technology that you're looking at specifically. Then of course when it comes to like the practical issue of where to protect, we heard earlier on like of course you would like to see patent protection, IP protection in the markets where you're going to produce or where you're going to sell. We heard Brazil today as an awkward example. I found Brazil as well. You should go to Brazil and protect over there. That's at least what I found. And David sort of like hooted it earlier as well, so I was listening to Brazil. Then because I didn't have that on my radar. Because I would say, like, of course, the obvious one is Europe and the US, but also Japan and also companies in developed countries where you have your competitors, of course, and where you basically want to stop competitors appropriating your intellectual property rights as well. Last but not least, what I found interesting in one of the online publications is there an awareness, a lack of awareness of opposition proceedings in the European Patent Office? So the idea is like if you see a competitor has been granted a patent, you can file for an opposition proceeding before the European Patent Office for 9 months after the patent has been granted, which is a very cheap way to shoot down the patent of a competitor. And so sort of like this data here, this publication I found mooted, is there like a lack of knowledge in regard to medical technology with regards to opposition proceedings, at least according to this author, which I found quite interesting as well. Now, when to file, there are, of course, I told you that the law tends to be quite similar. There are quite differences with regard to novelty. Because you know, many times, like when we talk to, we as patent lawyers, we talk to our engineers. And they always would like to publish what they've just like devised. We always say, no, please don't publish it because you're shooting into your own foot. Basically, because you've disclosed your invention, it's not new anymore, you cannot get a patent anymore. Which of course is harsh, it's very harsh, but this is sort of like the system of novelty that we have in Europe. And the United States has moved closer towards us, but it allows the inventor a 1-year grace period. Which basically means if you want to file for a patent in the United States, you can publish it 1 year before, or you can talk about it 1 year before and you will still get a patent because you're the inventor. You are getting a grace period. This does not as such apply in Europe. In Europe we do have grace periods for like half a year, but only if somebody steals your invention. Steals your invention basically if there's a breach of confidence. If you have an employee that goes within a half-year period and talks about your invention in public, which basically would anticipate your patent application. If that is done sort of like as a breach of confidence, you could still file a patent for these issues as well. Also, if you sort of like explore them, there's also another criterion with regards to international exhibitions as well. But think about like where you want to publish and when you want to disclose these things as well. And there are still some differences with regards to US practice and Europe. Now, emerging issues, what sort of like I found which could be relevant for the future, and at least something that we as IP lawyers are looking into right now, of course, like 3D printing, as I've mentioned to you earlier on. This is something which we, I don't know, deem to be very big. Policy-wise, it's very big as well. We have people from the European Patent Office who are very, very, very interested in this specific field. Personalized medicine as well, of course. I don't know whether Joaquin was talking about this issue about like personalized medicine, bioprinting as well, and of course like e-health, which is becoming more and more relevant as well with software applications in the health sciences as such. As an epilogue, housekeeping, yes, don't be ignorant, be aware. And this is what we always tell, like at least our engineer students, like look out what is happening, know your IP, so you should see what IP rights you have, and keep your discussion secret, and so forth. So these are just ground rules that we have with regards to intellectual property. Register your rights, of course, but that, of course, is then the strategic decisions. Look at the territories that you require protection then as well. And look at contractual issues as well. What I've mentioned with regards to copyright law, if you are, for instance, in Germany, if you are the employer, you would have to have a contract with him for the copyright, that you are the exclusive user then of the copyright of the author, because this is different in jurisdictions in Europe as such. With regard to trade secrets, is of course like, setting up non-disclosure agreements. I mean, I'm preaching to the choir. Useful help sites. I found the IPR help desk quite useful, I have to say. But of course, like also like the European Patent Office and the World Intellectual Property Organization give you a snapshot of things. Oh dear, I'm already late. Further reading, last but not least, because we are in Marseille, and I wrote a paper on bioprinting. As I've mentioned to you, we called it like the fifth element and the third dimension. I don't even remember the film, The Fifth Element. She was printed out, Lilo, who was then the wife of Luc Besson as well. So this is something for interest, and well, that's it. I hope I haven't kept you from dinner and stuff. Thank you.